So today I wanted to take a little bit of time to talk about the Supreme Court cases between New York Governor Andrew Cuomo and certain religious organizations that have been upset with his COVID-related restrictions in New York. If you're not familiar with the particulars, the state of New York has zones that have been established that are based on the severity of spikes in coronavirus. More cases, higher zone level. The zones are yellow, orange, and red, and all three of them imply certain restrictions for businesses and religious institutions and forms of public gathering. So for religious organizations, yellow has meant a 50% occupancy, basically that 50% of their occupancy could attend service. Orange has meant that 25 people could attend services, and red has meant that 10 people could attend services. So the argument from the religious organizations is that the red and orange zones in particular violated their right to free exercise of religion protected in the First Amendment. Now, if we look at what free exercise actually represents historically, there's not a lot of precedent before the middle of the 20th century. The first real case that we get that sets a precedent for it is one called Sherbert versus Werner, where a woman was fired from her job because she could not work Saturdays because of her religious observation of her holy day. The state that she was in asked that anybody who sought unemployment benefits, which she did, would make every effort to find new employment. And if you were not, you could be denied that unemployment money. During her search for jobs, she could not find a job that would hire her and would take her, with the caveat that she wanted her Saturdays off because she believed that Saturdays were a holy day for her. The Supreme Court ends up siding with this woman and ends up taking the position that she should get her unemployment benefits because she was making every effort within the free exercise of her religion, namely that she could not work on Saturdays. So what this ends up doing is setting a precedent so that people who were religious could claim that the law was burdening them unfairly based on their own religious principles and practices, and that they would be more or less exempt from a certain portion of that law within reason. This was taken up as a precedent in the Supreme Court and was upheld many times. But in 1990, we get a shift in that dynamic in a new Supreme Court case, Employment Division versus Smith. And in this particular case, the person involved used a state prohibited substance, namely peyote. And he took this while in a Native American church and ingested the substance, which is considered illegal in the state of Oregon. And the state claimed that this person was denied unemployment benefits because of this, because he violated a state prohibition. So given that, the Supreme Court ends up reversing a lot of its precedent, stating in this particular case that the free exercise clause permits the state to prohibit sacramental peyote use and thus to deny unemployment benefits to persons discharged for such use. Neutral laws of general applicability do not violate the free exercise clause of the First Amendment. So what this means, and what this is getting at, is that if a law is applied neutrally, such as a drug law for peyote, that is deemed to not be targeting a religious institution or organization directly, or people of a religious organization directly, that there is an exemption to the previous understanding. Essentially, you are not protected. I tend to find this extremely problematic because I think it prioritizes mainstream religions that are generally accepted and traditionally conform to the laws of the United States, and more importantly, that the US laws were kind of written around. To deny that the US laws were not written around Christian laws is kind of hard, because most of the founding documents mention the Christian God and a lot of other stuff. The secular God they speak of, the deist God, is a Christian entity. Most of the founders of the United States were Christian. So when you see a situation like this where a particular religious faith is losing its ability to practice, and really who's using peyote? It's mostly the Native American groups that are using it for certain ritual practices, then you are kind of allowing for a religious persecution. So I'm not sure how I feel about this particular reasoning, but this is the understanding of the Supreme Court in the modern era. So with that said, I do want to make one more claim while we start to look at the actual documentation of the Supreme Court. That is, first and foremost, the Supreme Court and even the religious institutions are not arguing whether or not New York has the right to be putting any sort of restrictions in play. As a matter of fact, as much as I've heard arguments that, it's from conservative groups that, they're being so authoritarian, the Supreme Court isn't even arguing that particular component of the case. Both conservative judges and liberal judges, as I'll show, are not having an issue with that. The issue is around whether or not this law is neutral and is being applied unfairly to the churches and synagogues that are in question, or if it is being applied fairly because it is a neutral understanding of the free expression of religion under the First Amendment. So this quote I have here is from Justice Kavanaugh, who's generally a conservative justice, who says, "The Constitution principally entrusts the safety and health of the people of the politically accountable officials of the states. Concurring in denial in application for injunctive relief, federal courts therefore must afford substantial deference to state and local authorities about how best to balance competing policy considerations during a pandemic." So essentially, Kavanaugh here is saying that the state has a right to be imposing some sort of junction or, some sort of legality around the situation of a pandemic. So that's not what's being called in question even by the conservative judge. And the liberal judge who speaks on this is Justice Breyer, who ends up saying, "We have previously recognized that courts must grant elected officials broad discretion when they undertake to act in areas fraught with medical and scientific uncertainties. That is because the Constitution principally entrusts the safety and health of the people to the politically accountable officials of the states. The elected branches of state and national governments can marshal scientific expertise and craft specific policies in response to changing facts on the ground, and they can do so more quickly than can courts. That is particularly true of a court such as this court, which does not conduct evidentiary hearings. It is true even more so, whereas here the need for action is immediate, the information likely limited, the making of exceptions difficult, and the disease-related circumstances rapidly changing." So nobody in this court case is arguing that, Cuomo's being this authoritarian leader who's just imposing things. The issue is on the fairness of the application of the law. And Justice Kavanaugh ends up going on to say his particular case, and let's get into that, okay? So moreover, New York's restrictions on houses of worship not only are severe, but also discriminatory. In red and orange zones, houses of worship must adhere to numerical caps of 10 and 25 people, respectively. But those caps do not apply to some secular buildings in the same neighborhoods. In a red zone, for example, a church or synagogue must adhere to a 10-person attendance cap, while a grocery store, pet store, or big box store down the street does not face the same restriction. In an orange zone, the discrimination against religion is even starker. Essential businesses and many non-essential businesses are subject to no attendance caps at all. So Kavanaugh is arguing in this particular case that the churches and synagogues are not being represented as the mandatory institutions like grocery stores are represented, and that there's a discrimination. However, and as much as this sounds valid, Justice Sotomayor ends up making a very, very strong argument against this, which I want to bring up. If we go to her argument, she says, New York applies similar or more severe restrictions to comparable secular gatherings, including lectures, concerts, movie showings, spectator sports, and theatrical performances, where large groups of people gather in close proximity for extended periods of time. Likewise, New York treats more leniently only dissimilar activities, such as operating grocery stores, banks, and laundromats, in which people neither congregate in large groups nor remain in close proximity for extended periods of time. So, Justice Sotomayor is ending up making a distinction between the essential businesses, grocery stores, banks, and laundromats, which do not have congregations, and also within the restrictions imposed by New York State, that would include doctor's visits, including acupuncture visits, and certain liquor stores. That these particular locations do not have people congregating in large groups and remaining in close proximity, where secular gatherings like lectures, concerts, and movie showings, spectator sports, and theater performances do. Sotomayor ends up going on to say, but Justice Gorsuch does not even try to square his example, and Justice Gorsuch uses the examples I mentioned just now of a liquor store and an acupuncture office as deeming them kind of non-essential. And we could argue that for days, what's essential and non-essential. That's not the point. The point is that the state has deemed these to be valid under the guidelines, that they are in some ways either essential or non-threatening. And I think that's the argument that Justice Sotomayor is taking, is that these are not threatening in quite the same way. And she goes on to say, but Justice Gorsuch does not even try to square his example with the conditions medical experts tell us facilitate the spread of COVID-19. Large groups of people gathering, speaking, and singing in close proximity indoors for extended periods of time. She further goes on to say that movie theaters, concert venues, and sporting arenas are actually subject to stricter things because they are closed entirely, whereas worship is actually left open with certain restrictions in play. She further speaks on Justice Gorsuch's position to say bike repair shops and liquor stores generally do not feature customers gathering inside to sing and speak together for an hour or more at a time. And epidemiologists and physicians generally agree that religious services are amongst the riskiest activities. Given all of that, and given all that information, I think it's very clear that there is a distinction between the types of businesses such as a store where people are generally in constant movement and people don't necessarily spend a lot of time talking to each other, versus people sitting in a location communicating and conversing for an extended period of time. And that's really the distinction that's being made here. And one more thing that I want to take a look at from Sotomayor's argument is the footnote that she has here, which is, she says, ironically, due to the success of New York's public health measures, the diocese is no longer subject to numerical caps on attendance it seeks to enjoin. Yet the courts grant this application to ensure that should infection rates rise once again, the governor will be unable to re-implement the very measures that have proven so successful at allowing the free and comparatively safe exercise of religion in New York. What this is getting at is these policies actually worked. All of the zones that were red and orange went to yellow quite quickly. And because of that, we now have a greater exercise and ability to practice religion in New York. New York has actually secured that by performing these shutdowns. So, given that, the governor now, under these new guidelines imposed by this particular Supreme Court case, is not even allowed to take the measures that have previously worked and have been shown to work, and that previous court cases have actually shown to work, but have now been overturned since the death of Ruth Bader Ginsburg and the replacement of Judge Barrett on the bench. Judge Barrett is the reason that this court case ended up going against Cuomo. I think that's something important to take into account, especially given that she did not present any sort of opinion on any of this. 5 justices spoke, and she was not one of them. But she was the decision that changed things from what Ruth Bader Ginsburg would have likely found to be the case. Being much more concise with that, Ruth Bader Ginsburg would have voted liberal. The court case would have gone 5-4 in favor of Cuomo, had she still been alive. Justice Barrett has not said anything, and the reason for that is unknown. But she had the change of opinion, and she still didn't address the court as to why. And that's unfortunate. That's very unfortunate, because it would have been nice to see what her precedents set and her reasoning behind things, given that she's probably going to be on the bench for a long time, and is a conservative voice on that bench that's going to shift a lot of positions in this country. One other thing that I want to talk about is actually something that Justice Breyer had actually stated. And he says, but whether in present circumstances those low numbers violate the Constitution's free exercise clause is far from clear, and in my view, the applicants must make such a showing here to show they are entitled to the extraordinary remedy of injunction. So this is actually a further argument than what's also been presented. The assumption has been that the state has had to provide some sort of proof that it was not causing harm to these places through the legal system. So a lot of burden has fallen on the state to show that its laws were neutral, which I have argued that they are, and therefore under the understanding of the Supreme Court should have voted the opposite of what it did. But Justice Breyer is actually arguing a step further, that the state is not responsible for that proof, but it is also the religious institutions' job to prove that they cannot function properly under that capacity. And I am going to argue that they can and have historically. I have an article here from the Pittsburgh Post-Gazette that says closed houses of worship served during 1918 flu pandemic. And this outlines how certain churches ended up not only shutting their doors, but also ended up setting up their churches as makeshift hospitals and basically triage rooms so that they could be used as makeshift hospitals in this time. This was important, and a lot of lives were saved because of it. And I have a quote here: "A very unusual opportunity has come to Calvary Church. The clergy of the Episcopal congregation in Shadyside wrote to its members, to meet the present emergency of our pandemic-stricken community, the Vestry Governing Board has tendered to use this parish home to the United States military authorities. The room will be used as a convalescent hospital for military trainees recovering from influenza." They literally turned their facilities into a triage ward, instead of having church services. Further, the article goes on to say, there were no live streaming options yet, but Calvary did send sermons, Bibles, readings, and prayer materials to members. The Pittsburgh Council of Churches asked families to use the 11 a.m. hour on Sundays for devotions, Bible readings, and prayer at home. And to further this, I have another article from Word and Way, which is a largely religious website and I believe newspaper, that made a very similar argument talking about the usages of emergency hospitals. and said, but unlike today, where churches are still gathering virtually on Zoom or Facebook Live, when churches suspended their services in 1918, they really quit meeting together. Instead, all they have is the home altar, as they called it. And they have a clip from an article in 1918, and I'm going to read this to you because this could apply to today. The Pastors' Conference most brotherly advises that every Baptist family hold family worship in the home next Sunday morning at 11 o'clock, if closing the houses of worship is ordered by the health board. Our people desire to be helpful in every way possible, so of course we will respect the requests and suggestions of the health authorities. But while closing the public places is in vogue, surely we can have worship in our own homes. There we can read God's word, pray, sing praises, and give thanks. If all the Christian people would ask God for the passing of the scourge, they would surely bring God's blessing upon the land, for the scourge would pass. In that way, we would surely be blessing the earth. Now, I'm not religious, and I don't speak to this particular faith or anything of it. But the fact that religious institutions during the Spanish flu in 1918 were willing to shut their doors. Some of them were angry and felt it was an inconvenience, but they shut their doors nonetheless. They were able to see beyond the immediacy of their religious service, and everything came back. Everything ended up coming back. It's not like this was some authoritarian restriction that just made the religion go away. It's not as if the religious institutions were treated unfairly. In a pandemic, it was the best way to handle that. And so I believe that the Supreme Court made an inaccurate decision in their current assessment. I also think that the current understanding of the law is quite flawed, especially the understanding that the ability to declare free exercise of faith is kind of bound in the way that it is. And I would argue that from a historical perspective, even though I said that it typically is in favor of majority faiths, it is actually the Catholic understanding of the sacrament of communion that would be called into question during Prohibition in the 1920s, whether or not they could have their wine to be the blood of Christ. So given all of that, like, you have this particular understanding that is already flawed within the Supreme Court. But under that particular understanding in the Supreme Court, it's still, no matter how you look at it, it's still upheld that these are not religious inconveniences. This is something understood as something that can be done at the home, can be done with the guidance of a pastor or leader or rabbi or whatever, to come up with some way to work around these restrictions in these times to speak to the wider issue, which is that people are dying. And sometimes, maybe this is my own nuanced perspective coming in, I think people forget just how severe and scary that can be in a world where we've eradicated a lot of diseases. I think in 1918, with measles, mumps, and rubella being so prevalent, people were very aware of the effects that a pandemic could cause. And maybe today we've forgotten that a little bit, especially with the movement of anti-vaxxers and other things. But there is no reason why these institutions need to be appealing to the Supreme Court, let alone appealing in this larger way to being open. I think it sets a dangerous precedent in these times when I do believe that certain institutions, and this is me, an anarchist, not really being in favor of the state, not being in favor of state-imposed sanctions and government intervention in this particular way, needs to come out and say, right now, this is the best system we've got. We have to kind of trust that the state is trying its best, that they're not trying to persecute, and speak to it after the fact, after the pandemic's over, after we've saved lives, because 250,000 people have died in this country. With that said, if you like this video, give it a thumbs up, hit the bell for notifications, and hit the subscribe button, please. If you feel so inclined, check out and follow my Twitter and check out the new Discord I have in my description. And with that said, my name is Anarchist Tara, and I hope you enjoyed watching.